Lawyers, which case caused you moral trauma, but the main solution came as an unexpected? Story 1. Lawyer faces ethical dilemma over destroying incriminating document. I once represented a very innocent company in a lawsuit which, if they lost, would have ended their company. I knew the owners. They were great people, and they absolutely didn't do what they were being sued for. Opposing counsel and their client were the scum of the earth. This was a widely shared opinion. One day, reviewing some documents before producing them, I came across a very, very bad document. I understood what it meant, but I also understood that it could easily be misconstrued, and if misconstrued, would virtually nail my client's coffin shut. I was traveling, so I put the document in my briefcase to take back to the hotel so I could talk with my co-counsel about it. That night, I didn't call my co-counsel, but I did stand in my hotel room, next to the trash can, for almost a half hour. If I tore up the document and threw it away, no one would ever know. My good, innocent client wouldn't have to deal with it. Instead, I put the doc back in my briefcase, took it back in the next day, and put it back in the pile of documents to be produced. The other side found the document and made hay for days with it. It was painful. We went to trial, and the jury found in favor of my client on every issue. They saw the truth, not the misconstruction, and, best of all, I got to keep my soul. Story 2. Judge denies valid claim due to late filing despite mental health issues. Most lawyers are not criminal defense attorneys. The vast majority of lawyers do other things. It's like asking ship captains of Reddit, and meaning oil tanker captains of Reddit. But anyway, the toughest moral dilemma was, when working for a judge, denying a valid claim simply because the person had filed paperwork late, past the statute of limitations. Story 3. Criminal lawyer cannot advise client on disposing illegal weapons. Criminal lawyer in Winnipeg, Canada here. Toughest are cases where you cannot actually tell the client what to do. I had one case where the client was alleged to have sprayed someone with bear spray and pointed a taser at the complainant. Citizens are not allowed to own tasers here. The police arrested him a few hours later. After I interviewed him, I had to specifically not ask what he did with the weapons. If I told him to throw them away, I am counseling him to commit a crime by destroying evidence. If I told him to keep them, also a crime, possession of prohibited device. It is unethical and possibly illegal if you counsel someone to commit a criminal act. So I can tell him what the consequences are of each choice, but I can't recommend he do one or the other. Meanwhile, client keeps asking me what to do, and all I can say is that you have to make your own decision. Story 4. Lawyer advises against pursuing weak case despite financial incentive. Throwaway. I remember one of my first moral dilemmas. I had a client with a fairly arguable case against another company. They were very, very motivated to pursue the suit, but their facts were pretty tenuous. At the end of the day, it was nothing more than a he said, she said situation. And quite honestly, their witnesses weren't the best. I was put in the position where I could take the case and make a good $20,000, or I could do the right thing and tell them that he'd be exposing himself to a huge degree of risk in a countersuit, based on weak facts. It wasn't really a dilemma, I guess. I explained to them that, given the circumstances and what they were alleging, it was anyone's game. I told them that in my personal opinion, it wasn't worth paying $20,000-ish to have an indefinite shot at more money. They ultimately agreed with me, but I can see how certain less scrupulous lawyers may have stirred the pot on that one. Oh yeah, you've got a case, let's hit them hard, etc. This is probably one reason why lawyers end up in ethical trouble. If you don't care about your clients, you can make a ton of money. Story 5. Defense attorney faces moral dilemma defending guilty client in heinous crime case. You are a sworn officer of the court, that's all. Oath. We've withdrawn for personal reasons, it happens. Here's a real-life scenario. Heinous crimes by the defendant. He is guilty. There is no "I didn't do it" bullshit. One of the victims committed self-injury, which multiplies the emotional impact tenfold, especially since it's a small community. There is no beat the case in this instance. He knows what he did. and accepts the consequences. The state had a law pertaining to the charges that contradicts the Constitution. It was based on the defendant's sexual orientation. Had he abused females, the charge would not apply. It was not fair. It was the defense attorney's job to argue and fight for the defendant to be fairly charged and sentenced. We were able to set a precedent that led to the statute being corrected. He'll die in prison, so no worries. The TV tells you that OP's question is the big issue for attorneys. It's actually a non-issue for defending guilty criminals. The ethics matter comes into with the other side, and how judges campaign. If you buy the $15,000 plate for Judge Smith's re-election campaign, you will find that your clients who land on that judge's track have a much easier time receiving a suitable result. You pay a bribe to judges as a criminal defense attorney to sell results to your clients. It's a no-brainer as an investment, but sad to see the real world. Imagine adding a pile of zeros to that donation, and you are now a politician. A competent criminal defense attorney is key to justice being served. You could be defending the most evil human to exist, but you wouldn't be helping them. You provide checks and balances against the other side to prevent failure of the system. While we all want justice to win, it takes an opposing force to make it just. Story 6. Public defender struggles with defending impoverished guilty clients against government power. I'm actually a criminal defense attorney, currently practicing. This question gets asked a lot, and the basic confusion is over the term guilty. Guilty is not a term of fact, it is a term of law, at least in the United States. Meaning guilty is a legal status. And like any legal status, there are criteria for qualifying. In this case, it is that your qualification is proved beyond a reasonable doubt. Meaning you are not guilty until there is proof established beyond a reasonable doubt that you are guilty, either through a trial or by your own admission, under oath, in open court. So, even if a client admits to their lawyer that they committed a crime, they are still not guilty of that crime until the presumption of innocence is overcome. The presumption of innocence applies in all cases, and at all court proceedings, including a jury trial, no matter the circumstances. And protecting that presumption of innocence, and making sure it is accurately and faithfully applied in all cases, requires applying it in cases involving key to people. It's really not the ethical dilemma so many people seem to think it is. My job is to 1. Try and secure my client's desired outcome for their case, and 2. Advocate for my client in court. If my client's desired outcome involves vindicating their constitutional rights, then that is what I'm going to help them do. If it involves taking a quick plea to get out of jail, that's what I'm going to do. It depends solely on the client. I believe that making sure the government can't mess with people is more important than any individual being guilty or not guilty. The government has incredible, terrifying police power. Any person can be arrested, detained, and questioned by the police at almost any time. Even if you didn't do anything, it will take hours to get it sorted out, and in the meantime you will be deeply scarred by the traumatic experience. Without the presumption of innocence being faithfully applied by defense attorneys like me, police would actually start doing that. It's not a slippery slope. Look at what police do to minorities when they think nobody is looking, or even when they know they are being filmed. Do you honestly think it wouldn't be worse without people like me to call them out on it? Or... Story 7. Shadowing DA during child harm investigation. Before I became an attorney, actually. I'm from a pretty small town. Through a connection of my parents, I was able to shadow the district attorney DA for a summer during college. I expected to be going to an awful lot of driving under the influence, DUI, statutory rape and burglary trials, since that's most of what showed up on the police blotter. The night before I was to start, I went to bed very early. What can I say? I was excited. My parents were off on vacation, and I was just home with my big brother. After I had been asleep for a short time, my brother came into my room. "The phone is for you. It's the police." "Hi, Hoovy. It's the district attorney." I know you're not starting with us until tomorrow, but how would you like to get started tonight? Wear jeans and boots if you have them. I didn't even really say anything to my brother. I just got changed quickly and went to the police station. Turns out, a woman in town had set her home on fire with her 2 children inside, causing both of their deaths. I was up all night with the DA during the initial investigation. He took me to the home. I had to climb up a ladder and onto the roof to get into the girls' bedroom. They shared a room but had separate beds. I was told by the police that, when they found them, both were in the same bed, meaning they were awake when the house was on fire and crawled into bed together, terrified. The neighbor was a police officer. He saw that the house was on fire, ran over to try and help, and was told by the mother that the kids were still inside. He couldn't get in to save them and was just devastated. The rest of the day is a blur, an exhausting and traumatizing blur. I went to the autopsies. I got dizzy and had to leave the room. Honestly, the case was so devastating that I tried to wipe it out and didn't follow it much once I went back to college. A quick search tells me that the mom pleaded out to avoid the death penalty, which I knew the DA was going to fight for. She'll be in prison for the rest of her life. Well, I didn't expect my first Reddit post to be so serious. Too long. Didn't read. Woman set her house on fire to cause harm to her 2 small children. Story 8, representing rapist in excessive force lawsuit. Well, there's nothing here, so I'll go. A federal judge called up a senior associate at my firm a few years ago and asked us to take on a case for a pro se plaintiff. That is a guy representing himself. The judge's personal rule, and it's a good one, is that if a pro se plaintiff gets past summary judgment, he finds them pro bono attorneys. Getting past summary judgment, long story short, means the facts have been disclosed, and there's at least a question of who's right. We took the case by applying the time-honored principle of, don't turn down a federal judge when he asks a favor, idiot. The guy was the plaintiff. He was suing some cops, the town, and the county. Our client had led the cops on a high-speed chase through a fairly dense town, and he went to jail for like 6 to 10 years for it. I forget now. What he was suing for, though, was that the cops used excessive force on him when he was arrested. No matter the crime, once the cops have you controlled, they can't just start beating you up when you're in handcuffs. So, not a sympathetic case, but you get used to this. Your goal is just to make sure they get everything the law entitles them to. Then, at our first interview, 2 disturbing factors came up. 1. When going through his life history, he mentions that, one day in his youth, he was on substances and kicked out of his class at college. Pissed off, he goes into the parking lot, finds a girl standing by her car, and rapes her. Yep, our client is a rapist. He spent 10 years in jail for that. Now, obviously, rapists can be unfairly treated 15 years later, and everyone deserves equal protection under the law. But yeah, it's a lot harder to get emotionally involved in support. Story 9. Lawyer friend deals with emotional toll of criminal law cases involving mentally ill clients and threats of violence. Not a lawyer. I have a close friend who works for a law firm focused on criminal law. It takes an incredible emotional toll on them. Mental illness is an overarching theme, over and over again. The client stopped taking their meds, goes off and ends up in jail. One recent client is diagnosed with whatever, and so is his mother. So he is constantly being manipulated and basically dragged into her mess. He never had a chance. Most of my friend's day is spent answering calls from jail. They call and call, but they never get through to the actual lawyers. They are trapped and scared, and all my friend can do is talk to them and try to treat them like a human being for the 5 minutes it takes to tell them no one is available and to try calling again. Like I said, it takes a huge emotional toll to balance being kind and professional to someone you know is mentally ill, but at the same time is charged with horrific offenses. I could go on, but the thing I think gets to her the most is the threat of violence. When clients show up at the office, angry. when they are face to face with someone who is capable of anything. I think the most disturbing day was when a Special Weapons and Tactics SWAT team camped out at her desk for an afternoon, while detectives picked up the lawyer from a golf course and took him into protective custody until they caught the client, who was armed and prepared to harm everyone involved with his case. She felt like bait waiting for a guy with a gun to burst through a door and be ambushed and shot by police officers with assault rifles. All in all, a pretty messed up way to earn a paycheck when you have a baby at home. Story 10: Lawyer uncovers false rape accusation by young Marine's mother against him. It was a young Marine who was accused of severely harming his 5-year-old sister. I was working on it for a friend who was also an attorney. It was his first time dealing with a case like this. Everyone wanted a pre-trial conviction for the young man. After hearing the accusations, the Marines drummed him out. So I did some detective work. It turns out he used to give his mother half his paycheck every month. And now he was stopping that. He believed his mother convinced his sister to accuse him. They had no physical evidence, just the testimony of the young girl. So we had the psychologist ask the girl if Mom told her to say anything. And finally, the truth comes out. Mom promised her gifts. Story 11: Struggling with document disclosure in a high-stakes case. Did you ever represent a client while knowing that they are guilty? Every lawyer that practices criminal law has done this. This is not a moral dilemma. You don't go up and lie. Most cases aren't about the client's actual innocence. It's about other things. Did the cops follow the right procedures? Does that state meet its burden of proof, etc.? Greater than what was my biggest moral dilemma. I often have moral crises in discovery. Basically, in discovery, opposing counsel can ask you questions and make you produce documents. But when you're working for a big case with a big company, things can get complicated. For instance, depending on how I interpret their question, I could send them a couple thousand pages of relevant documents, or hundreds of thousands of pages of irrelevant documents, with the 1,000 pages of relevant stuff mixed in there somewhere, and make them find it. And, of course, there is always the temptation of not producing unfavorable evidence. Story 12: Representing a corporation in an unfair foreign dispute. I once worked on a case where a multinational corporation had caused severe environmental damage to a relatively impoverished country. I was on the corporation side. It was interesting on moral grounds because the corporation, was 100% not legally responsible anymore, and 2, the country was absolutely corrupt and using massive conflicts of interest to screw over the corporation without giving them a fair trial. So I had no problem sleeping at night, but you still feel bad just saying it's your problem now to the small country. Story 13: Helping organizations with opposing personal beliefs. I sometimes help nonprofit organizations get charitable status with the Internal Revenue Service, IRS. Ordinarily, this is great fun, and I love the work. However, I've helped a few organizations that I was morally opposed to. For example, I once helped a religious organization whose sole mission is the opposition of gay rights in the United States, gay marriage, gay adoption, legalization of gay consensual sex, domestic violence rights for gay victims of abuse, etc. I fully support gay rights, and that was a difficult project for me. Another time I helped a gun control organization even though I disagree with gun control. For projects like that, where they are permitted by law, I do my job and help the organization because I'm a professional and I don't let my personal opinion interfere with my work. Within reason, I'm not going to help anybody do something that is illegal. Story 14: Facing unethical client demands. You aren't going to get many specific examples because attorney-client privilege prevents attorneys from sharing those details. As others have said, representing guilty clients is not a moral dilemma. In fact, in many states, there is a rule of professional responsibility which requires you to zealously advocate your client's position. If you can't do it because of some personal reason, you have to withdraw representation. The toughest moral dilemmas I face as an attorney. 1. When a client asks me to do something that might be construed as unethical and refuses to take no for an answer, or even worse, has an explanation of why it is not unethical that actually makes sense. Always a hard situation. 2. When I witness an attorney for another party do something borderline or questionably unethical, but it helps my client. The temptation is there, of course, to pretend you didn't notice. Usually you can get the other attorney to correct it without doing anything yourself, but it can be troubling. 3. Situations where a judge should recuse him/herself because of bias or relationship to a party, but you don't want to make that argument because you will lose goodwill with the judge by making he/she off. Overall, though, I would say the long hours and problems balancing work and family time are a much bigger struggle for our profession than moral dilemmas. Story 15. Emotional toll of defending in a horrible case. Not a lawyer, but worked in law firms on some janky cases before. You just have to suck it up. One of the lawyers sent out a mass email about a truly horrible case we were working on. Thankfully, we lost. It was that bad of a case. He said, "We will all be affected by this, but we need to do our absolute best for our client. We can joke around with each other about what we're dealing with, but it never leaves the office." Everyone came in slightly hungover most days during that time. Story 16. Defending guilty clients against mob justice. Mew father was an attorney and then a judge, and was telling me about a case where his client was very guilty. I was aghast, but he told me that this is the United States of America, and even the most terrible criminal has someone by his side to make sure that he is fairly judged and sentenced. Being that my father defended people who were about to be lynched more than once, he saw firsthand what mob justice was and how due process is a good thing. Story 17. Conflict over client's admission of guilt in UK system. I used to be a lawyer, United Kingdom, not United States. If I was representing a client in the police station, and they told me they did it, and then they told the police they didn't do it, then I would have to excuse myself from the case. I couldn't tell the police why, couldn't be a witness against the defendant, but neither could I represent him. Story 18. Ethical conflict in representing a sympathetic client against a vulnerable employer. Facing it right now as a young attorney. I work in plaintiff-side employment law. Part of what I enjoy about the job is feeling like I'm helping the little guy. David versus Goliath type of thing. Recently, I began representing client A, who is incredibly sympathetic. An older person who worked 85+ hours per week caring for a disabled child, took no holidays, no weekends, etc. for 2 years. Unbelievable hours, non-exempt, never paid proper overtime. Terminated after discovering the child died while sleeping due to the medical condition/natural causes, rather than being assigned a new client as A was promised. Needless to say, A has a substantial claim to unpaid wages. I knew A's employer was likely a small business, but didn't expect how true this was. After sending a demand and getting into contact with employer, I discover that not only is employer's small family business not doing well, the owner is an elderly man who is undergoing chemo and on death's door. The rest of the family is frantic and unprepared. They are uninsured and unrepresented. I have advised them countless times verbally and in writing to retain counsel, in every way, shape, and form I can think of, including citing directly to my jurisdiction's ethical rules. They refuse to retain counsel and insist on going through this process pro se. They say I sound fair/trustworthy over the phone, precisely because I have warned them that I do not and cannot represent their interests. They have cried, telling me about how they're going into debt to pay the reduced settlement amount. I believe they are being candid. On one hand, my duty is to zealously represent the interests of my client. I have been reasonable, advised my client to reduce the demand to something recoverable. I have fulfilled my ethical responsibilities to warn employer about proceeding without counsel. But, on the other hand, damn, this one doesn't feel good no matter what I do. My client is owed money, that is true. But A is not on the edge of poverty. I feel like I am destroying a terminal, unrepresented cancer patient's family and life work to do my job. Story 19. Refusing to bribe a county commissioner in land use law. I do land use law. I had a client hire me to rezone a property for him. I did some homework and told him we weren't going to win. We didn't have the votes. He told me to bribe the county commissioner who was blocking the rezoning. I was stunned and told him to get out of my office. Ironically, that commissioner was indicted later for taking bribes on zoning matters. Story 20. Ethical dilemma of accepting potentially ill-gotten retainer funds. Retainer funds. If a client has no apparent employment, is an accused substance trafficker, and places $7,400 down in cash to retain, do you have an obligation to inquire as to the source of the funds? Could you be willfully blind to being in receipt of the proceeds of crime? If the client tells you that it is funds raised from crime, what are your obligations then? Story 21. Discovering partner's embezzlement and being blamed as junior lawyer. Founding partner and my boss stole $5 million from multiple clients and figured it out, or at least that there was a problem. I caught holy hell when I started trying to figure it out. At one point, he tried to blame me. I was 2 years out of law school when it went down. Story 22. Handling mother's self-injury threat in juvenile dependency case. A few years ago, I practiced juvenile dependency. I was court-appointed counsel to parents who had their children taken away from them. I was appointed to represent a mother whose baby was removed from her care shortly after she left the hospital after giving birth. She had major mental health issues, but was also undergoing severe postpartum. I first meet her at the shelter hearing within 24 hours of the child being removed to determine whether there is probable cause to keep the child in state custody. Right before the hearing, the mother tells me that if the state finds probable cause and places her baby in foster care, she had plans, very specific, to harm herself. I had to scramble to keep my composure before the hearing and then call the state's bar ethics hotline because I really didn't know what to do. It was awful. Story 23. Navigating client's lie, leading to emergency relief in family law. Family law. I had a client describe to me some circumstances which I investigated the best I could in the time allotted. I filed an emergency motion and got relief for my client. During the hearing on the motion, client lied to me about something and I didn't know. Opposing counsel found out and called me on it. I had to withdraw the motion and apologize to the court. It was embarrassing, and I felt like a fool. Story 24. Pursuing defenses for guilty clients without denying facts. Attorneys owe a duty of candor to the court. So technically, a criminal attorney that knows her client is guilty of a particular crime cannot pursue a defense that presumes innocence of that crime. Attorneys also owe a duty of zealous advocacy, loyalty to their clients. Taken together, a lawyer who knows her client is guilty of a particular crime should pursue a defense strategy that focuses on affirmative defenses and mitigating factors. If you feel unsafe with your thoughts, please seek professional help. This video does not promote illegal activity. Stories are shared for commentary and education. Story 25. Torn between client duty and family ruin in an employment case. As a young attorney in plaintiff's side employment law, I represented a sympathetic client, A, an older person who worked 85+ hours per week, caring for a disabled child, never paid proper overtime, and was terminated after the child's death. A has a substantial unpaid wages claim. However, I discovered the employer is a small, struggling family business, with the owner, an elderly man undergoing chemo, on death's door. The family, uninsured and unrepresented, refuses to retain counsel despite my warnings, crying about going into debt to pay the reduced settlement. While I fulfilled my duty to zealously represent A, who isn't on the edge of poverty, I feel like I'm destroying a terminal cancer patient's family and life work, leaving me morally conflicted. Story 26. Caught between ethics and a partner's pressure to draft a prenup outside my expertise. As a new attorney, a partner at my firm demanded I draft an antenuptial agreement for his uncle, despite the uncle living in a state where I was admitted but having zero experience in family law or prenups. I knew state law could be particular about them and felt uncomfortable, but the partner shouted at me, calling me incompetent. I declined the task, refusing to risk ethical breaches. The pressure and conflict led me to quit the firm a few months later, highlighting the moral trauma of standing firm against a powerful colleague. Story 27. Navigating a client's self-injury threat during a custody hearing. Practicing juvenile dependency, I was appointed to represent a mother whose baby was removed shortly after birth due to her major mental health issues and severe postpartum. At the shelter hearing, she told me if the state found probable cause to place the baby in foster care, she had specific plans for self-injury. I scrambled to keep composure, then called the state's bar ethics hotline, feeling lost and awful, as I navigated the ethical duty to protect her while ensuring her safety, highlighting the emotional toll of such dilemmas. Story 28. Handing millions to a known human trafficker. I had a situation in which a nephew was caring for his aunt, her house, and finances. After the aunt died, we stepped in as special administrator and discovered the nephew had siphoned millions for years. We recouped some lost money, only to find out one of the beneficiaries was one of the largest human traffickers in the southern United States, the son, who was out on a technicality. I had to personally hand this guy a check for $7.5 million. Talk about internal conflict for me. Story 29. Pleading guilty against viable defenses for early release. The big one for me is when clients, bail denied and entitled to the presumption of innocence, deny allegations but have a good shot at trial. However, trial is months past their time served date on an early resolution offer. They want to get out as soon as possible, damn the principal. To what extent can we take the position of, we don't judge the facts our client gives us, and let them plead guilty? When does it cross the line from professional detachment into willful blindness? Does it serve the client to get off record and let them make necessary admissions pro se? Or does that risk derailing everything and abdicate our duty? Story 30. Defending clients who may intimidate witnesses. In big city prosecution, you have a backlog of cases and must plead out some bad guys who should be locked away for extended periods. For example, you walk in with an obvious career criminal with multiple break-ins, but plead to a largely suspended sentence with credit for time served because it's not worth the time. Another dilemma. You bind people over for trial who you know are going to be harmed by people higher up. You looked these people in the eye. The judge says there's probable cause, and you know the odds of them surviving are in God's hands. Story 31. Lawyer grapples with referring clients to firm exploiting immigrant tenants. The original poster, Robert, describes being friendly with an attorney specializing in landlord rights and having referred significant business to his firm. They learned the firm advises mutual clients to notify Immigration and Customs Enforcement, ICE, about non-paying tenants with only a tax identification number, implying precarious immigration status, leading to detentions and subsequent abandonment notices. The poster feels uneasy, noting the practice is used as leverage to regain property possession, and seeks advice on this ethical dilemma, highlighting the moral conflict of continuing to refer clients given the impact on vulnerable tenants. Story 32. Tenant defense lawyer witnesses landlord's immoral tactics against immigrants. Karen, a tenant defense lawyer, shares their experience of seeing landlords, especially those with licensing or habitability issues, threaten to call Immigration and Customs Enforcement, ICE, if tenants don't leave or pay up, targeting both non-citizens and people perceived as brown. They describe tenants fleeing in fear, leaving possessions behind, which landlords then trash. The lawyer emphasizes the scummy and immoral nature of these tactics, aimed at bypassing eviction protections, and urges others to stop referring clients to such lawyers, reflecting on the moral duty to stand for decency and tenant rights. Story 33. Lawyer faces ethical conflict over reporting immigration status in rent disputes. Ian explains their understanding from their barred state that it is unethical and potentially illegal to report or threaten to report someone to authorities to resolve a dispute unless the reported issue is causally related to the dispute. They provide an example, demanding $500 for a stolen TV by threatening to report someone as an Iranian spy is unethical, even if true, as it lacks causal relation. They apply this to the situation, noting reporting tenants' immigration status in rent disputes violates ethics, creating a dilemma between legal advice and moral responsibility. Story 34. Retired lawyer refuses to defend pedophile due to moral convictions. A retired lawyer shared that during their career, they refused to defend a pedophile because they believed he was guilty based on what he said and his request to fabricate a defense, such as harshly cross-examining victims to make them seem uncredible. The lawyer, who started as a police officer, viewed legal work as a game of finding doubt in prosecution cases, but drew a line at defending someone they felt was clearly guilty and manipulative.